Hi, I'm Dele Olawanle of Dele and Co. Solicitors. Contact us for advice and representation and advocacy in all areas of immigration law. We take your case from the onset until the conclusion of the case. We provide a one-stop service and we provide advice and representation and advocacy.
Dele & Co. Solicitors. We're friendly, professional and cost effective. A one-stop shop for immigration affairs as we take your case from the onset and represent you in court if necessary. Located at 659 Green Lanes, Haringey, London, N80QY. We're only 4 minutes walk from the Turnpike Lane tube station on the Piccadilly line. Call 0208 880 9393. That's 0208 880 9393 for more information.
Dele and Co. Solicitors. Legal advice you can rely on.
Hello viewers, welcome to today's program on immigration matters. I am Cynthia Arthur. With me in the studio is Mr. Dele Olawanle of Dele & Co. Solicitors.
Good day to you.
Good day, sir. Lovely
Yes.
to see you as always.
Yes.
Please introduce yourself and update us on what this program is about.
Yeah, good to see you. This is a platform that has helped, I dare say, millions of immigrants in the last 15 years that have been doing the legal panorama. The main purpose of this program is to equip immigrants and non-immigrants alike and citizens on the UK immigration law knowledge, understanding, explanation, because sometimes you look at the rules, they look the same. You look at the, you look at the application form, they look the same, and many things are not straightforward. And also, I saw a lot of people in the past who thought that they made the right application, they made the wrong application. They thought they had applications at the Home Office. They discovered that there was no application there. So things have been up and down for many immigrants. Many have been removed or deported from the country through ignorance, and ignorance of the law is not an excuse. So this program is to educate people, to let you know that, well, this is what you can do, this is not what you can, this is what you cannot do, these are the process you need to follow, these are the documents you need to get, this is how much it will cost, and also is it time to make an application or do you have to wait till later? How feasible is it for you to make the application, and what are the chances? So you need to know. If you don't know, you'll just be throwing good money after a bad case, and it could run into thousands and thousands of pounds. So we do advise people on this program. We give hints because even the law is confusing on its own to us lawyers and judges. So we take the law, we break it down. That's been going on for over 15 years. It has helped a lot of people, and we hope it helps you too. Yeah.
Thank you for that introduction. Coronavirus came and disrupted a lot of things. How have you been able to cope during this season as you also battled COVID-19?
First of all, I survived coronavirus, COVID-19, and many people that I knew survived it, and we just commiserate with the families of those who lost their lives in the pandemic. May their soul rest in peace. It has been very disruptive. It has been something that came and, messed up our chemistry, messed up our biology, messed up our physics. Who could have thought that students will not be able to do the O-level or the A-level exams? But kudos to the authorities, the educational authorities that decided on how they are going to arrive at a decision for them. So it has been very challenging, but things are getting back to normal. We have been able to see clients, online by having a virtual meeting with them, via Zoom, FaceTime, just name it. So things are getting back to normal. We've been doing a lot from home. The interesting thing about the home office applications now is that it's not paper based, it is online. So most of the work we can do it just sitting, having in our home, in our library, just walking away, in our car, walking away, because it's not paper based. So we can do it online. So in the areas of immigration, it has been it has been wonderful, and things are getting back to normal. And we are still representing clients. We are still doing case management hearings, and some cases also will be done online. By telephone, by Zoom, by any means available. So we are still in our operation, and then you can't suspend the legal justice system, because they say we are frontline workers. We have to keep the yes. I remember when this. Period when they say you can't leave home, you can't do this, you can't do that. Uh, Someone just said to me, I said, well, you can leave home actually because you're a frontline worker. I said, yes. It was like I won a trophy. Yes, and I went to the office and did one or two things that night. It has been an interesting period, but we are all in there, hanging in there, and we whatever comes, we are going to stand, and we shall win.
Keeping hope alive.
Yes, yes, that's the word. Yes.
What are the ways immigrants can regularize their status?
Regularization of status. You know, there are many ways now. There is a lot of options. First of all, the people who are dependents of EA nationals, you need to know whether you are applying for permanent residence or settled status or pre-settled status. Don't forget, all this you can do till June 2021. If you don't do it, if the time passes, you may be, hanging, your stay in the UK may be hanging by the threads, depending on what happens between us and the European Union before the June 2021. So, and time flies. So, I want to say to you, don't think you have time. Some of you who have lived there for 5 years or more should be looking at applying for settled status. Some of you have not lived there should be looking at applying for pre-settled status, and that brings you under UK immigration law. If you want to live here, I will strongly suggest do it for yourself, do it for your children, do it for your spouse, do it for your family now. Don't say you are going to wait. That is that one. For people who are from outside the European Union, also, if you need to regularize your stay, if you have no status, maybe you are an overstayer or you are an illegal entrant, and I've always qualified that on this program that we do not advise anyone to come here and overstay. When you come, your visa expires, go back, or you apply to change your status. If you don't do that, it's a criminal offense. So if you are caught before you make an application, your case becomes aggravated in that what they are going to say is that if they had not caught you, you wouldn't have done anything about your situation. So if you're an overstayer, you came with a visa and you did not renew your visa and your visa expired, you are an overstayer. If you came into the UK, with another person's document, which you are not supposed to do, but they didn't catch you, you are an illegal entrant. And if they had known who you were, they wouldn't have allowed you in. So therefore, but after a while, you develop what is called a private and or family life in the UK. You need to get legal advice on what you can do. You will need a lot of documents showing that you have been here, because how you prove that you have been here is through documentary evidence, utility bills, pay slips, bank statement, and things like that. If you are able to have those ones, don't tear them, don't destroy them, Don't throw them down the toilet because your friend said, oh, you shouldn't identify yourself. But only a madman or a mad woman destroys their evidence on the way to court. And I know you are not mad. Stop destroying your documents. Keep it safe in a safe place, because when you come to us or any other lawyer to say you want to make an application, those are the documents we will need to help you to make an application with the chances of success. I saw a client who came to see me years ago. He had lived in the UK for 17 years, but he only had one BT bill. And when I told him that he would need other documents, he was shredding his document, his bills. He said there were too many. So once he moves from one apartment to the other, he will shred the bill. And when he tried to make his application and ask those utility bill companies to get the bills, they said no, they couldn't help him. So as a result of that, he went from one lawyer to the other, spent thousands of pounds, and still couldn't have his status regulated. He couldn't regularize his status. Why? Because he threw away his documents. So you are going to need documents. You are going to need the good news, welcome, parents' evening from your children's school, all those documents, annual report of the children to show what they have been doing, what you've been doing, the evidence from your doctors. I have someone also who had lived in the UK for about 22 years and had not regularized his stay. The only thing he had was a doctor, a GP. And then when I asked him that where, okay, that we will write to your GP and get your medical record, he said he has not been going, that in the last 7 years, he's only been there once because he's a healthy man. um, I just laughed. I said, well, you are now too healthy, because even your medical record cannot help you. So what I'm trying to say is there is a lot that you can do, even before you make your application, to make sure that you get the necessary documents. You can still get documents, legal documents, not fake, not false, but by paying attention to what you have to do now. Stop destroying your documents. And if you have not registered anything with your name, you better do, because that is what we use in the Western world to prove that we have been here.
Okay. So do not throw away any evidence and put everything together, as that is what is going to help build up your case. And what is the 7-year policy on children?
Yes, it's now within the immigration rule that if a child has lived in the United Kingdom for 7 years, and then and the parent and the child may apply for leave to remain, the policy favors single parents more. Yeah, but they have been giving it to couples also, that they will not seek to remove the a child that has lived there for 7 years, or that was brought in the UK to the UK and has lived in the UK for 7 years, but and is under 18, still under 18, that they will not seek to remove them unless it is reasonable to do so. Reasonableness is not defined. So what it's about is to make sure that they act in the best interest of the child. So when it comes to reasonableness, it depends. You can't say, well, this is how they are going to determine it, but then strong legal representation could make the difference, can make the difference in whether it is allowed or not, it is granted or not. And if it is not granted, if you go to court on appeal, the representation before the Home Office or the UK Visas and Immigration will be instrumental towards winning that appeal, depending on what you put before them. If you put nothing before them, you can still say something in court, but the judge may not be with you, especially if you had legal representation when you made the application. So therefore, the policy is there. It's a rule. It's within the immigration rule. It has helped a lot of people. It can still help many others. but you have to make the application, not just rely on the application form. Legal representation also have to deal with what is reasonable, what is not, why it is not reasonable to remove the child or the children from the United Kingdom.
Right. Does that mean once a child reaches 7, getting leave to remain is automatic?
No, of course not. So that is where reasonableness comes into it. They said they will not seek to remove a child unless it is reasonable to do so. Now, what is reasonable? We don't know. It has no definition. So, but when you make the application from the onset, it has to be made clear why it will not be reasonable to remove the child
Okay.
or the children from the UK. You have to make a case for each case. So no two cases are the same. So therefore, the case has to be presented as strongly as possible, supported by with case laws or objective evidence of the country in question. If you don't do that, and then the application may be refused, but you can still win on appeal if you're able to prove that it will not be reasonable. And we talk of the integration into the community. Does your friend child have friends to whom they are used to? They have relatives here? Do they have health condition? So and a child may have a health condition and not have relatives. Some may have relatives and not have health conditions. So that was why I said no two cases are the same. But until you try, you won't know whether your application will be granted. But some cases are better than the others. But again, the judge, if your case is refused, a judge has the discretion to decide whether he will allow your appeal or not. They have a lot of power. So I've won a case in the past where the child was not even 7. He was 6 years, 7 months. But that judge really had compassion on the couple and said he'll be allowing the case. And he did. So what I'm trying to say is that without trying, you will not know. Yes.
If you've just joined us, you're watching Legal Panorama. I'm Cynthia Arthur, and I've got Mr. Dele Olawanle of Dele and Co. Solicitors in their studios to help us with our immigrational issues. What can people do if the application is refused, and how fast do they have to act?
Yes, as we were saying earlier, if you make an application, unfortunately, it's not all applications are granted the first time it is made. Some even had to make an application 2 to 3 times. But what I'm going to suggest and advise is this. There is no point putting in repeat applications if your circumstances has not altered significantly or changed. So bear that in mind, because when you make an application, I had a client who made an application 4 times within a year before coming to us. And he simply worked against himself because it's the same home office, it's the same system, it's the same computer, is this, do you understand?
Yes.
So don't think that by just making an application and we're talking of a lot of money, so that you have to show what has changed. So if you make an application and it is refused, then you have to appeal. You have to act very fast because you have 14 days or 5 days, depending on what stage of the appeal process you are in. And then make the application on time. Make the appeal on time. Get legal advice. So that when you are drafting the ground of appeal is being drafted, a lot will be put there on why you want them to grant your allow your appeal, and the case has to be prepared well. You have to prepare very well. Don't just put it there and just say, "Oh, God will do it," which is what many Christians do. Preparation is very important because the judges, despite the fact that I said they have a lot of power, also in some cases they have limited powers because they have to follow the rule, and they have to be able to say why they are applying, why a particular case is different from another case. In the case of appeals, especially when your appeal had been dismissed in the past and you had previous judgment from judges, a judge will have to be able to say why this particular case is different from the application you are making now, the decision that he's dealing with now, the appeal he's dealing with now is different from the one that had been decided earlier, because they have to look at the previous decision that had already been made by the previous judge. Previous determinations are very crucial. So if you have had a previous refusal, that means that the preparation for the current case has to be very strong and has to be different from what was presented before, has to be argued strongly in the way, not just arguing blindly, but argued strongly based on law, based on changed facts, the situation that has altered significantly or partly after the previous decision was decided. So this has to be taken into account, and that's why I suggest get a lawyer to represent you, so that tell them there was a previous decision and you have been to court before, so that they can consider, or because when you get to court, the starting point will be the previous decision. Whether it was 5 years ago, 7 years ago, the new judge will have to start from there. And he can only say that he's allowing your appeal based on a significant difference in the case.
Wow. So on that basis, what are the things they have to do once they put in their appeal?
They have to go on a scavenging mission for yes for documents. Try to get maybe their record from the HM Revenue and Custom, records from their GP. Maybe they have to obtain, if they have a health condition, they have to get current medical report on their situation, and they have to gather documents relating to their length of residence in the UK. It depends on what their case requires. That is what they have to do. But preparation is key towards winning an appeal. When the preparation is good, even the judge will commend your lawyer for preparing well. So he has to be prepared well. So it's not that you put in your appeal and you forget about your lawyer. You have to stay in touch. You have to ask that, what do you have to do? Because they'll write a client care letter to you, but a lot of clients leave it until the dying minute before getting back to the lawyer. Don't do that. Don't be like that. Yeah.
As they say, proper preparation prevents poor performance.
Yes.
So we need to prepare on time. How can your firm assist people whose application are refused?
Yes, I argue most of the cases in court, and I have a wealth of experience behind me. I've argued all over the United Kingdom, including Scotland, Northern Ireland, Wales, and England. Over the years, yes, we can do all things when it comes to immigration matters, when it comes to appeals, when it comes to judicial review, and you can, yes, take on your appeal, lodge the appeal, prepare the case bundles, have a conference with you, and represent you on the day. We can do all things. Yeah. Yes.
They can do all things because of the wealth of experience that they have
Yes,
behind them.
yes.
And how can your firm assist immigrants who want to regularize their status?
The same way, what they have to do is to book an appointment. The number is on the screen. Call the number, book an appointment, come and see us. When you call, they will tell you that you will pay a consultation fee. It is not negotiable. Even if you are my wife, you will pay consultation fee. It is to advise you so that you don't throw good money after a bad case. We will advise you, we will talk to you on the merits of the case and the things you need to do to put in place to be able to make an application. Don't run away. I've seen clients that they said you pay consultation fee in the past, not knowing that, when they call, they put down their name and things like that. They didn't pay the consultation fee. They went and spent over £12,000. They lost the case, and they brought the appeal to us. If they had come to us initially, we wouldn't have advised them to make the application, and they wouldn't have lost that money. So get legal advice so that you don't throw a lot of money after a bad case. But if you have to make an application, we will tell you.
Right, there is a consultation fee to be paid, nothing to be scared of. At least it would help you get the expert advice that you need in order to help you make the right application. What will be your final word for viewers?
Final word is stay safe for the rest of your life. Because this COVID season is a total nightmare, caught us all by surprise, but we are bouncing back. We will never give up. So don't give up and don't change the dial. Tell your friends about Legal Panorama, and we hope to see you shortly.
Do not change the dial. You've been watching Legal Panorama with myself, Cynthia Arthur. I'm Mr. Dele Olawanle of Dele & Co. Solicitors. The telephone numbers are on the screen. You can contact them. There is a consultation fee to be paid. Also, you can follow them on all social media platforms on Facebook, Twitter, Instagram. They are there live and they'll be willing and ready to answer all your questions and help you put in a healthy application to get a great outcome. Thank you very much.
Hi, I'm Dele Olawanle of Dele & Co. Solicitors. Contact us for advice and representation and advocacy in all areas of immigration law. We take your case from the onset until the conclusion of the case. We provide a one-stop service, and we provide advice and representation and advocacy.
Dele & Co. Solicitors. We're friendly, professional and cost effective. A one-stop shop for immigration affairs as we take your case from the onset and represent you in court if necessary. Located at 659 Green Lanes, Haringey, London, N80QY. We're only 4 minutes walk from the Turnpike Lane tube station on the Piccadilly line. Call 0208 880 9393. That's 0208 880 9393 for more information.
Dele & Co. Solicitors. Legal advice you can rely on.